Okay, good morning, everybody. We have 50 or so of you at the moment. We're expecting quite a few more, but we will kick off with a quick introduction and other people can join us in a moment. Thank you very much for coming and welcome to Lee & Thompson's 2021 contract law update. 2 weeks ago, I was going to say very nice to see you, but I can't actually see you at the moment, but maybe I'll be able to in a second. 2 weeks ago, we had a fine crowd of eager contract lawyers here in our office in Charlotte Street. It was a real pleasure to see everybody in person and talk to everybody and see them talking to each other. And I know some of you on today were hoping to come last week and couldn't make it, but lovely to see you here today, and also welcome everybody else who's joining us today. We last did our contract law update session back in 2019, rather remarkably. 2020 came and went. We had some sessions on force majeure and some other things, but we didn't have our contract law update. But we couldn't let 2021 go completely without sharing a bit of law with you. So here we are. So today you've got me, Dominic Bray. I'm a partner here at Lee & Thompson. I head our litigation team. And very happy to have with me Franja Cooper, who's a senior associate in our litigation team. Why a contract talk from a couple of litigators? Well, we love a bit of law, and we spend a lot of our time dealing with things when they go wrong. So we like to use that experience to help you stop things going wrong, and also to make you better prepared when things don't work out quite as you plan. We also quite often get asked to advise on tricky drafting and negotiation issues. So what's the impact if we agree to this? How should we deal with that issue? Those kind of things. And we're also often asked to come in when contractual issues start to go a little bit pear-shaped. We're often asked to see what's the contractual position here? What are our rights to help you know what your position is to guide the negotiations that you might be having with the other side. So today we're going to give you some law. We're going to take you back to some core principles, take you back to law school every now and then. We're going to give you some useful snippets to share, hopefully, with your commercial teams when they come charging in at you and say, what does this mean? You don't need to see the whole contract, do you? Or they haven't got a leg to stand on, have they? Or we've totally screwed up here. Is there anything in our contract that's going to help us? All those kind of things we're going to be looking at today. So what are we going to cover? As before, we're going to, for those of you who came last time, we're going to follow the lifespan of a contract from start to finish. Not everything, because we haven't got time. But we're going to look at it in order as things happen. So we're going to first look at formation. Do you have a contract? Do you need to worry about things that you say that don't make it into the contract? There we're looking at misrepresentation. We're going to look quickly at duress. So you've entered into a contract that you now don't like. You felt you were under pressure at the time. Can you now get out of it? Then, assuming you have a contract, what does it mean? That's a question of interpretation, something the courts are always coming back to. And even if it doesn't say so expressly, do you have an obligation of good faith? Quite a lot of things in that over recent years. Then we're going to look at what happens when it all starts going wrong. We'll look at penalty provisions. We're going to look at exclusions and limitations of liability. And then we couldn't do a contract law talk in 2021 without having a little look at force majeure. Some of these we covered last time, but these cases keep coming. So there's clearly plenty of appetite to argue about these things and also plenty of scope to get it wrong. Why Mythbusters? We've called this Mythbusters today. Well, what we've seen in a number of these cases is that there are decisions which to some extent go against the grain of what you might think is the law. There's nothing particularly groundbreaking here, but some useful reminders. Perhaps good faith, there's been quite a lot of developments there. But if you're still using your 1995 law school notes or your 2000 edition of Title on Contracts, there might be a few surprises for you. There are very few cases in the media and entertainment sector, in the creative industries, but the principle, a lot of these are about oil and gas and travel and airlines and things like that. But the principles we're going to talk to you about are exactly the same. So don't worry if we're asking you to look at an IT contract. We've got 9 topics in about 90 minutes, so roughly 10 minutes each. So a whistle-stop tour of each of these issues. Not a detailed analysis of each case, but some key pointers and takeaways for you. And if you want to read the cases afterwards, we will be sending you the slides, which have got all the case references on them. And if you feel like watching this again, or you've got some colleagues who couldn't make it this morning, we are, I hope, recording this session. And so it will be available to you afterwards. A couple of other final points. If you've got any questions, please submit them through the Q&A, not through the chat. The Q&A is easier for us. That will also mean, maybe a good thing, that the only people who can see the question is us, but we will be reading them out as we go through. The easiest thing is going to be if we deal with questions at the end of each section. So we've got 9 different sections. We'll have a pause at the end of each one, and we'll deal with any questions then, if you have any. And we'll also have some time at the end if you've got anything which comes up as we're going along. We will finish by 11 o'clock at the latest. I suspect we'll finish a bit earlier than that, and we'll have a 5-minute comfort break in the middle, so you can stop staring at your screen. And that should be around 10 o'clock, might be a little bit earlier. We'll see where we get to. And to keep you on your toes, we've got a little pop quiz as we go through. And you'll just have to have a look at the slides, see who they are, see who the act is, and let us know if you know who they are. Right, so that's all of my introduction. The way we're going to break this up is I'm going to deal with the pre-contractual stuff. So that's formation, misrepresentation, and duress. So that's your first section. Then Franja is going to look at the tricky things about contract interpretation, implied terms, and good faith. And then I'm going to come back and finish off with penalties, exclusions of liability, and force majeure. So essentially break it up into 3 sections. So let's start with formation. Pop quiz number 1 for you. So do you have a binding contract? This is the question. And our first myth here, heads of terms are not binding. So we often see people saying this. These are just heads of terms. They're not binding. It's an agreement to agree. It's not enforceable. And this question often comes up because there may have been a plan to use a long form contract, but it never happened. It was never entered into. And then there is a question as to what is the status of these heads of terms? Are they binding or not? And our myth, heads of terms are not binding. Well, as good lawyers will know, the answer to that question is it depends. It depends on what the heads of terms say, and it depends on the circumstances in which they were agreed. So here, let's take you back to law school. And it depends in particular, fundamentally, on whether the heads of terms meet the basic requirements for an enforceable contract. So is there offer and acceptance? Is there an intention to create legal relations? Is there certainty? And is there consideration? And these are the things that the court considered in our first case. So this was Green Deal marketing against economy energy trading. Lots of issues in dispute, but for these purposes, the relevant question was whether the heads of terms were binding, as that affected the termination rights and the price that could be applied in any damages calculation. So Green Deal carried out door-to-door sales to try and get customers to switch energy suppliers to EE. And in 2015, they had a partnering agreement. In 2016, they agreed some new heads of terms. It was a 4-page document, quite detailed commercial provisions in there, including, importantly, some new rates. Then in 2017, things started to fall apart and both sides tried to terminate the relationship. So we had an underlying contract from 2015 and then some heads of terms in 2016. And were those heads of terms binding? So there was nothing in the heads of terms themselves about whether it was binding or not. So you often see that kind of clause, these terms shall be binding, or these heads of terms shall not be binding, or sometimes specific terms will be binding. Generally a good idea to say whether it's going to be or not. So here we had this provision at the start of the heads of terms. This document sets out the heads of terms that will form the basis of an agreement between EE and GDM, and that both parties will work together to agree a formal contract within 90 days of commencement. So you look at that and you might think, these are the heads of terms that will form the basis of an agreement. Is that binding? You might think perhaps not. But then look at those words, to agree a formal contract within 90 days of commencement. So those were quite important. So how did the court approach this? The two core questions that they were asking was there an intention to create legal relations? And were the terms sufficiently certain to be enforceable? So looking at intention first. So intention is an objective test based upon what the parties communicated to each other through their words or their conduct. And in a commercial context, it's quite difficult to disprove that there was not, to show that there was no intention to create legal relations. The general assumption is that there was. So here we had a heavily negotiated contract, heads of terms, 4 pages. The parties had been discussing it for several months. The terms were very detailed. There was a celebratory mood when the heads of terms were signed. They went crazy and ordered Wagamama as a celebration meal. Wild times. And the judge looked at this wording within 90 days of commencement. And he said, well, commencement means commencement of the heads of terms. That indicates that the parties were intending that they were going to be binding. All of this together indicated that they were meant to be binding, even though it didn't actually say so. And the court said the fact that a formal contract was contemplated didn't mean that the heads of terms were not meant to be binding. It made complete sense that they were going to hold the ring until the long form contract was signed. So intention to create legal relations, yes. And then the court had to look at certainty, and these things are bound up together. So were the heads of terms sufficiently certain to be binding? Did the parties know what they were agreeing to? And here we had a 4-page heads of terms with some quite detailed commercial provisions in them. And the court said, yes, they were sufficiently binding. It had the terms, it set out the services, it set out what the payment was meant to be. So it didn't matter in that context, again, that the intention was that there was going to be a long form contract. So I'm going to just deal with the second point here at the same time, and then we'll deal with any questions that we have as we go through. Because this is in a similar vein, looking at our similar myth here. Subject to contract is meaningless. So we're going to look at a case on subject to contract, which went to the Court of Appeal last year in 2020, and then quickly another one on without prejudice. So hopefully we all know that with subject to contract is not meaningless, but it's not always as clear as you may think. So here we had a case, Jo-Ann Properties against Moneything Capital. The details of what the dispute were about doesn't matter, because this is actually about whether there was an agreement to settle that dispute. So they were in some settlement discussions. There was correspondence going both ways, headed subject to contract and sometimes without prejudice. But in some of the communications, those headings were not put on the communications. After a while, the claimant, Jo-Ann, proposed terms, and the defendant, Moneything, said, agreed. Then Moneything tried to file a consent order to settle the proceedings and record that agreement. Moneything actually tried to include some additional terms in that consent order, but for these purposes, we don't need to worry about that. The core issue was whether or not the offer and the agreement in correspondence headed subject to contract was binding. So Jo-Ann Properties said that there was no binding contract. So at first instance, the court said there was a binding contract, that there was an offer and acceptance, and that it didn't matter that the communications were headed subject to contract. They said they had reached a deal. The Court of Appeals said no. Subject to contract means that neither party intends to be bound until a formal contract has been entered into. And interesting here, the fact that some of the communications were expressed to be subject to contract and some of them weren't, didn't matter. Once you start something which is subject to contract, everything that follows is subject to contract, unless and until both parties agree to lower the subject to contract umbrella. Hence our second pop quiz question. So it didn't matter that some of the communications in the middle were not expressed to be subject to contract. Here, there was no agreement that the communications, the subject to contract label was going to be removed. So what you have to show, and the Court of Appeals said, is that the judge seriously undervalued the force of subject to contract on the legal effect of those negotiations. In order to remove subject to contract, both parties have to agree that the agreement is going to be open. So on a similar basis, in the recent Sex Pistols litigation, where we were acting for one of the parties in dispute with Johnny Rotten about the upcoming Sex Pistols documentary by Danny Boyle. So one small part of that case was that Lydon was trying to rely on a without prejudice exchange regarding a dispute in 2014 about how certain advertising revenue was going to be divided between the band members. Most of those communications were headed without prejudice, except for the last one. And the argument was that because the last one wasn't headed without prejudice, that waived the without prejudice privilege. But in a similar way to the subject to contract case, the court said no. So once you start without prejudice communications, they're all without prejudice, unless until somebody says that they're not. And that accords with the general principle of without prejudice communications. It's about the substance of the communication, not how they are labeled. So some practical points there. First, in relation to subject to contract, remember, both parties need to agree to remove the subject to contract condition. It doesn't necessarily matter that you might forget sometimes. So we often see this, you have lots of communications, emails firing back and forth. Sometimes somebody might forget to put without prejudice on it, or they might forget to put subject to contract on it. That in itself isn't going to be fatal. But if you want something to be subject to contract or without prejudice, obviously always best to keep that label. Regarding heads of terms, best always as a drafting point to be clear whether they're intended to be binding. Is it all intended to be binding? Is none of it, or are particular clauses? State that in your heads of terms. And also cover off the risk that that long form agreement that everybody intends to sign might never happen. We see that a lot. We see it a lot with marketing agencies. We see it a lot in film and TV. Very often that long form contract doesn't happen. So are there things that you want to put in your heads of terms, some important things, just in case that long form contract doesn't happen? So that was, that's it on that formation point on subject to contract and without prejudice. So I'm just going to pause there for a second and just see if we have any questions on that section. I've got one. So the question, so this was on green energy, I think. Had the older contract expired? No, it hadn't. So the heads of terms were intended to operate. So the heads of terms were intended to supersede the old agreement, but at that point it hadn't expired. So the question was whether the heads of terms applied or the underlying contract was to apply. Okay. So moving on, unless Franny, there's any other questions.
So there's another question here in relation to that first Green Deal energy case, was whether the parties had been acting in accordance with the new terms on the heads of terms at all.
Yes, they had, which was another important question in considering whether or not the parties had intended to be bound. So yes, that's a good point, and often an important issue is, well, what have the parties had? What have the parties been doing? Does it look as though they were intending to be bound? And yes, they had, and that went to answering that question as to intention to create legal relations. Okay, so moving on, misrepresentation. Myth 3. So the question here, the myth here, I can say whatever I like in a negotiation as long as it doesn't appear in the contract. And the question here is, when can a negotiating device, a bit of puff, something you say in a completion meeting, when does that become a misrepresentation, a fraudulent misrepresentation? Do you have to be careful about what you say in negotiations? So this is a case from 2019, and it's a case about the price of eggs, but it could be about the price of anything, and it's about what you say in your negotiations. So it could be about the cost of COVID compliance on a film or advertising production, for example. So it's about eggs, but it doesn't have to be. So this was actually a case which arose out of the avian flu outbreak in the US, which was extremely difficult, and in particular for egg producers and the producers of dried egg products. So Rembrandt, one such company in America, had to slaughter 50% of their chickens and find new suppliers of egg products. And BV Nederlandse, Nive as they're known in the case, was one of them. So they are a Dutch supplier of dried egg products. So Rembrandt entered into an agreement with Nive for the supply of dried egg products. And then after that contract had been signed, they then negotiated a price increase based on the increased cost of compliance with US regulatory requirements. Nive said to Rembrandt, this is the cost. They provided a detailed breakdown and thorough calculations, as they are referred to in the judgment. Based on that price breakdown, saying that this was the additional cost that was going to be incurred as a result of complying with the stricter regulations, they agreed a price increase of 2.5 euros per kilo of dried egg product. Nive did not say that the price increased a profit element, which in fact it did. So all of the calculations presented to Rembrandt were on the basis that this was the increased cost. So later on, the relationship started to break down. Rembrandt asserted that Nive had not complied with the US regulations and terminated the contract. Nive said, no, that's not right. We did comply with these regulations. This was an unlawful termination, and now we want you to pay us 19 million euros for our loss of profit. So the question was whether the price under the original agreement should apply, or the price increase of €2.50 per kilo. That made a significant difference to the loss of profit claim. And the question there was, were these price calculations presented as the additional cost a misrepresentation, such that the second contract should be rescinded, void, and we had to go back to the first contract to look at the price that was payable? So the first instance, the court said that the costing was a negotiating device. But nonetheless, it was a negotiating device which was based on something which was not true. It wasn't a genuine estimate of the increased costs, as they'd said. It included a profit element. And the judge said that Rembrandt, the US company, might have acted differently had that misrepresentation not been made. So the price increase was unenforceable. That was appealed. And the main issue on appeal was causation in a misrepresentation claim. So what effect did the misrepresentation have? Now, the usual test for causation on misrepresentation is that but for the representation, the claimant would have entered into the contract. So here, accepting the new price. But where you have a fraudulent misrepresentation, so where somebody knows that something is untrue, or if they're reckless as to whether it's untrue, the test is different. You only have to show that they might have acted differently. So in the case, there's a lot of cross-examination of what Rembrandt would have done had it known that there was a profit element in the calculation. Obviously, nothing wrong with it from a negotiation perspective to try and make some money, to include a profit element. But the problem here was they hadn't said that. They'd expressly said that this was only about cost. So on cross-examination, Rembrandt were asked, well, what would you have done if you'd known that there was a profit element? And the answer was, well, I don't know. You're asking me a hypothetical question, but I might have acted differently. I might have gone to a different supplier. I might have asked some more questions. And the Court of Appeal said, well, that was enough. The test for a fraudulent misrepresentation is whether you might have acted differently. So again, the Court of Appeal agreeing that was a fraudulent misrepresentation and that the price increase should be rescinded, leaving the original contract with the lower price as the binding agreement. So some practical points there. For some, that might seem a bit alarming that you're having a price negotiation, you put forward some numbers, and then you're bound by them. And the other side of that is, well, if you're putting forward some numbers and you know they're not true, why shouldn't you be? There's obviously nothing wrong with increasing the price, but don't be deceptive about why you're doing it. And what can you do to protect against this? Well, normally you try and exclude liability for misrepresentation in your contract, but you can't exclude liability for fraud. So if you know you're saying something which isn't true, you're not going to be able to exclude liability if somebody comes along and says that was a misrepresentation. For non-fraudulent representation, you'd normally include an exclusion for misrepresentation. But just remember here that your usual entire agreement clause is probably not going to be enough. So what the courts have said is that you need clear words to exclude liability for misrepresentation. And that's why you have the no reliance type wording. We're not relying on any statement which had been made before this contract was entered into. So those are some practical points here. So just be careful. Your commercial teams don't get carried away with what you're saying to the other side, and make sure essentially that what you're saying is true, or better to say nothing than to say something which is untrue. So that was all we had on misrepresentation. Franny, do we have any questions on that? I don't think we do, but if not, we can save them till the end. No, I can't see any in the Q&A. Okay. So number 3, last one from me for now. Economic duress. When can you get out of an onerous contract? This was something which has been on people's minds with COVID. In a number of sectors where business was low, people found themselves signing up to onerous terms to win business. When things picked up, they didn't like the look of these contracts so much. And the question comes, can we get out of this? I was put under enormous pressure to sign it. I didn't have any choice. My business was about to go under. When can you get out of an onerous contract? And the myth here, if I'm pressured into signing an unreasonable contract, I can get out of it later, can't I? And the answer is no, other than in very limited circumstances, as we will demonstrate now with another case. So this is a 2019 case, times travel. Our third pop quiz question. Think air, in the air, one for the older viewers this morning. So Times Travel and Pakistan International Airlines. So the background to this. So Times Travel is a travel agent based in Birmingham, which had the priority of its business was the sale of flights for the Pakistani community. So traveling between Birmingham and Pakistan. At the time, Pakistan International Airlines, PIA, was the only airline offering direct flights between the UK and Pakistan. This was back in 2012, remarkably. The case took a very long time to get to trial. So that was pretty much all that Times Travel did, was transport people to Pakistan. So very dependent on PIA's business. PIA had a number of travel agents, including Times Travel, that had claims against them for unpaid commission. Times Travel's claim against them was for £1.5 billion. And what PIA did, they said, okay, I know where you are, well, they didn't actually say this, but I know you have these commission claims against us, but we're going to terminate your contract. And you can only have a new one if you agree to waive all the claims that you have against us. And not only did it say that to Times Travel, but it also said, oh, by the way, we're going to reduce your ticket allocation unless you include this waiver as well. So aggressive stuff, but all permissible under the contract that they had. They had a right to terminate. So that in itself was perfectly lawful. So Times Travel signed the agreement. So it's got no choice. Our business is dependent upon you. We've got to do this, otherwise we're going bust. But then it sued PIA to say that it only entered into the new deal as a result of duress. And at first instance, Times Travel won. The court said, yes, you were under exorbitant pressure here, and you are entitled to get out of this contract. But on appeal, the decision was reversed. The Court of Appeal said there was no duress here, and then Times Travel appealed that. So the appeal concerned the difference between unlawful act, economic duress, and lawful act, economic duress. So duress usually applies where there's a threat of unlawful pressure. So, for example, there's a threat of a breach of contract, or more sinister, a threat of physical violence if you don't sign this contract. But here, the pressure wasn't unlawful. They were perfectly entitled to terminate and entitled to try and get a waiver of claims. So the test is, what is the test, when there is lawful act duress? And what the court has said, the Supreme Court here on appeal from the Court of Appeal, is that where the duress is lawful, you have to show these three things. So you have to show there was an illegitimate threat, and that was a significant cause in inducing the threatened party to enter into the contract, and they effectively had no other alternative other than to give in to that threat. And here what the court said, there was nothing illegitimate. The Court of Appeal had said there had to be some element of bad faith. And the Supreme Court said, no, that wasn't actually the test. The test was whether or not there was something morally reprehensible or unconscionable, without going into great deal as to what that actually meant. One of the lords in the Supreme Court did think that there was a bad faith element here, but the question being whether or not they genuinely believed that they were entitled to make the demands that they were making. But all of the lords in the Supreme Court thought that this was not a situation where the law of economic duress should apply. So despite it being very aggressive action, it was lawful, and this wasn't sufficiently morally reprehensible or unconscionable for the law of duress to apply. And the court acknowledged that this was pretty harsh. So despite the harsh result, it's not appropriate to develop the law of duress in such a way which would fetter the use of a monopoly position. That is left to competition law. So you can protect against abuse of dominance through competition. You can protect innocent consumers through consumer protection law. You can stop the abuse of unreasonable terms through the Unfair Contract Terms Act. So you've got all those different things, and the court's essentially saying this is all in place. It's not our position to try and help people out beyond what we already have. So the lessons from this one are, in very broad terms, you can be as aggressive as you like, provided it's not unlawful. Try not to do any physical violence. And the other side of this, if you sign up to something that you don't like, it's going to be very difficult to get out of it from the law of duress. You might have misrepresentation, you might have other claims, but duress is going to be a very narrow doctrine. I don't think you're going to be able to rely on it. So that's all on duress, and that's enough from me for the time being. I'm going to pass over to Franja in a second. Just pause for a moment to see if we have any questions in relation to duress. No, we don't at the moment. Maybe you'll have some later. So I'm going to pause. I'm going to hand over to Franja now. It's 20 to 10. Franja's piece splits into two. So I think what we'll do is we will look at the interpretation point first, which is going to be about 10 minutes or so, a little bit more. And then we'll have a 5-minute pause, and then we will continue with Franja dealing with good faith. So I will put myself on mute. Sorry, I'm going to put myself on mute, and then I'm going to hand over to Franja.
Okay, so moving on to interpretation, and our myth here is, Dominic, can you change the slide, please? Thanks. So the myth here is it doesn't matter what the contract says, we all know what it meant. And this is something that people come to say to us from time to time, which is worrying. We see people trying to rely on emails or earlier drafts of documents to try and override what's written down, or to support a particular interpretation of a provision. And so the question here is, how much can you rely on documents outside of the contract when you're interpreting what it means? And for this point, we're going to a case about coal mining in Wales. Not the most exciting judgment, but the only facts you really need to know are that there was an escrow agreement being entered into between a mining company and the borough council. And that included a payment provision, which the parties were arguing about. The question was whether the company had to pay by these quarterly payment dates, or could it wait until the long stop date and pay it all then? And in supporting its interpretation, the company wanted to rely on a pre-contractual proposal document. So the question was here, what did the meaning of the payment provisions mean? And so to do this, the court had to carry out its usual interpretation exercise that it does whenever it's looking at a contract. And there's a reminder here on the slide of what that involves following the Supreme Court's decision in Wood and Capita a few years ago. So that case confirmed that what the court's trying to do is determine the objective meaning of a clause. So to do that, they need to look at the natural and ordinary meaning of the words on the page. So, what's the obvious meaning of what's written down? You need to look at the context of that provision in the agreement as a whole. So what do all the other provisions say? Is there anything that helps? And then you can also look at the commercial context. And this is where external documents might be relevant, because you can rely on those to establish what the commercial aim of the contract was. However, on the other hand, you've also got to remember the exclusionary rule. And this is a well-established rule, which means that you can't rely on pre-contractual documents in support of a particular interpretation. And the whole point of this is to ensure certainty. The point of having a written contract is that parties can rely on what's written down to record what's been agreed. And this rule applies even if you have express communication showing that the parties reached a consensus on meaning. So even if you had an email that says clause X actually means Y, you still can't rely on it when interpreting that clause. So these two principles do seem a bit contradictory, and judges have said in some of the case law that there's a fine line here when you're looking at these documents. On the one hand, you can look at them when you're trying to establish facts that are relevant to the commercial context and the aims of the contract. But on the other, you can't rely on them to support a particular interpretation, even if you've got something in writing that's expressed. You might be able to rely on external documents to establish a misrepresentation claim, like Dominic was just talking about, or an estoppel, depending on what was said and when. We're not going to talk about estoppel in much detail today, but in summary, it means you can rely on an external document if you've changed your position in reliance on it. So going back to our case, here, the judge said this wasn't a case where there was a fine line and these issues really came into play. The judge held that although the proposal was evidence of the commercial purpose of the transaction, which was basically to create an escrow account as security, it couldn't be relied upon to support this interpretation of the payment provisions. And in any event, the judge said the interpretation of this clause was really clear and the company had to pay the instalments as they fell due. So some practical points from this case. I mean, this comes up fairly often where we have clients trying to tell us to ignore, it doesn't matter that it says this, we've got these emails that show what everyone meant. And so the key points to remember are, the interpretation exercise involves looking at a clause by itself and in context. And that's why we're always asking to see the whole contract when we're asked what a clause means. I mean, we often have people come up and say, oh, what does clause 3.7 mean in a 50-page agreement? And, we always have to say we need to read the whole contract. It's not because we want to rack up fees, but it's because we can't advise on one clause in isolation because of this interpretation exercise. The starting point is that you can't rely on external documents. If you've got emails going back and forth saying, oh, actually, this provision means something else, then why not amend to make the contract clear? If the other side doesn't want you to do that, that raises a bit of a red flag that, they're trying to say that what's written down isn't actually what's been agreed. And then obviously as a basic point, when you're drafting, just take a step back, check that the agreement includes everything it needs to. If you're looking at heads of terms or a proposal, go back and double check that everything that was meant to be covered is covered. So moving on to the next myth or assumption, which is the flip side of what we've just discussed, which if the words are clear, you don't need to look any further. And for this, we're looking at this 2020 case between WinLink Marketing and Liverpool. And there are 2 points that come out of this case. Firstly, what happens if you use a capitalized term in an agreement which you don't define? And secondly, when can you imply terms into a contract? And this case is a fairly rare example of where an implied term argument has succeeded. A quick summary of the facts here. So WinLink was a company that introduced sports rights holders to potential sponsors. And in 2013, it entered into an instruction agreement with Liverpool. In 2014, it introduced BetVictor as a potential sponsor. And in 2014 and 2015, BetVictor made 2 offers to Liverpool, but both of which were declined. The following year, however, Liverpool did enter into a training kit sponsorship deal with BetVictor, and WinLink turned up and tried to claim commission. So the question here was WinLink entitled to commission? The agreement said that WinLink was entitled to commission on any agreement, and it said entered into during the introduction period. However, introduction period wasn't defined. So the court had to look at 2 questions. Firstly, what did introduction period mean in the absence of a definition? And secondly, on the facts, had this provision been breached? So on the first question, on what did it mean, the judge said that basically it had to mean something. There's a quote here that in essence, he was saying, unless something makes absolutely no sense at all, you can't just ignore it. The parties have included that wording for a reason, and we need to work out what it says or what it means. And this means going back to that all-important interpretation exercise. So here, there were other provisions which helped determine the meaning of what introduction period meant. These included the fact that WinLink's appointment was non-exclusive. So Liverpool could be speaking to other people through different avenues. Liverpool could terminate the agreement with WinLink on 30 days notice, and any accrued rights survive termination of the contract. So the court decided that what introduction period meant was during the term of the introduction agreement itself, and it applied whether or not the contract was concluded before or after the agreement was terminated. However, that wasn't the end of the matter here, because this agreement didn't include the standard agency contract wording that you often see, that the introduction by the agent must be the effective cause of the transaction. So that's something you often see in agency contracts, or sometimes you might see wording that the agent must have substantially negotiated the contract, but basically that they've been responsible for that contract being entered into. So on implied terms, that means going back to the test from the M&S case from 2015, which basically says that a term can only be applied if it's necessary to give business efficacy to the contract, or it's so obvious that it goes without saying. So this is a pretty high bar. You can only imply a term if it's strictly necessary to make the contract work. So going back to the facts of our case, the judge said that here this test was satisfied. As a matter of principle, he said, you shouldn't get commission as an agent unless you're an effective cause, especially when you've got a non-exclusive agency agreement like we had here. And on the facts here, the 2016 deal that Liverpool eventually entered into was very different to the ones that WinLink had introduced. And it had been brokered by someone else, so someone who worked at BetVictor who wasn't connected to WinLink at all. And he said that it would be a very unreasonable outcome, contrary to business common sense, if WinLink received commission. So even though introduction period could in theory apply after the agreement ended, here, because WinLink wasn't the effective cause of the agreement, no commission was due. So moving on to some practical points from this case. This is something that comes up a lot. We recently had a case, for example, where the term affiliates wasn't properly defined in the contract. So, and there was a dispute really over whether it meant affiliates at the date that the contract was entered into, or did it include affiliates that joined the group afterwards. And this had a huge impact on the outcome of this dispute and whether a non-compete provision had been breached, and a difference of potentially millions of pounds of damages. So, really this is a drafting point. You don't assume a capitalized term won't have a meaning and just leave it in. Do a really careful proofread, maybe use drafting software, go back with a fresh pair of eyes. We all know that drafts go back and forth with endless tinkering, and it's really easy to lose sight of what you're actually trying to do. We end up with these kind of monstrous clauses where everyone's fiddled with all the different words and it doesn't really make much sense anymore. Does it actually read properly if you didn't know the background? You don't want to end up in a position where you've got a judge criticising your poorly drafted agreement like you did in the WinLink case. Another practical point is obviously be really careful when you're importing clauses from other documents. We've all got our favourite clauses that we like to copy and paste, but you just have to be really careful. Make sure that any internal implied terms are properly defined and that there's no inconsistencies with the defined terms. And finally, don't assume that you can rely on implied terms. The example we've looked at shows that you can sometimes, but the threshold is high, and don't assume that this is going to save you. That's it from me on interpretation. Don't know if there's any questions before we have a quick break.
So we're going to have, there's no other questions on that at the moment. But just to reiterate what Fran has said there about being very careful about drafting, in particular, importing clauses from one contract into another. Fran and I must have had at least half a dozen cases of that nature over the last couple of years, all of which have had quite a significant impact on the value of the claim. And just because it's so easy to do, is to either work off a previous contract and then you're in quoting terms from that one because you say, oh, well, that looks good, let's stick it in this contract. But just making sure that all the defined terms that you have are consistent with this new contract. And also ensuring if you're using terms and you want them to be defined, that they actually do have a definition. It sounds quite simple, but it's surprising how often these things do go wrong and lead to some quite chunky arguments about what it actually means. So we're going to have a little pause now just for 5 minutes, and then Franja is going to come back and continue to talk about the very interesting issue of good faith and how that has changed over the last couple of years. So we will come back. It's now 9:54 on my clock. We will come back and start again promptly at 10, which is 6 minutes, not 5. Thank you. So welcome back. I hope you're all still with us. We'll just have 30 seconds and then we'll get going with part two. Part two, Franja is going to talk through good faith and how that's developed over the last year or so. And then I'm going to come back in and look at the three issues about when everything starts going wrong, which hopefully it never will, but sadly sometimes it does. So there we go. I'm on 10 o'clock now. So Franja, back to you, please, to talk about good faith.
Okay, so good faith. The myth here is that, can you change the slide, please, Dominic? Sorry. There's no obligation to act in good faith in commercial contracts. And it is true that there's no overarching obligation to act in good faith under English law, unlike in some countries where there is. But this is a very fast developing area of the law. And a judge recently said that it hasn't reached a stage of settled clarity. We've seen lots of decisions in this area over the last couple of years, and I think we're going to see more. So watch this space, it is changing. And we're seeing this reflected a lot in real life, with good faith arguments being raised much more frequently. People seem to chuck it in to letters all the time at the moment. So part of the reason why it's become more of a big deal recently is in light of the Bates and Post Office case from a couple of years ago. So you might have heard about this. This is a group litigation brought against the Post Office by hundreds of sub-postmasters who operated local post offices. And the background to this case isn't particularly relevant to commercial contracts, but it is worth a mention as it's pretty shocking. So basically all the sub-postmasters who were setting up the sub-post offices had to use the Horizon accounting software that the Post Office told them to use. And under their agreements with the Post Office, the postmasters were responsible if there were any accounting shortfalls. And the Post Office very aggressively pursued them when there were shortfalls. This led to people being bankrupted, convicted, imprisoned on the basis of theft and false accounting. I think 39 people ended up in prison. One woman who pleaded guilty was sentenced to 15 months when she was pregnant. And throughout this whole process, the Post Office denied that there were any issues with Horizon at all. And they made each of the sub-postmasters believe that they were the only ones experiencing problems, when in fact lots and lots of people were having issues. So the sub-postmasters worked out what was going on, and they brought this group litigation against the Post Office, claiming that the shortfalls were caused by the bugs in the Horizon system and that they shouldn't be liable for them. There was lots of different issues in play in this litigation, but what we're focusing on today is whether or not there was an implied duty of good faith in the contracts, and if so, what did that mean for the parties? So good faith can be implied in something called a relational contract. There's no set definition of what this means, but there's various characteristics that are relevant in working out whether you've got one. The only factor that is determinative is the first one. So you can't imply good faith if it's expressly excluded. And the rest of the list here are some of the other factors that might apply. It's not exhaustive, but it's some of the factors that are relevant. So in the Post Office case, the judge looked at these contracts and said that they were relational. There were loads of relevant factors, but some of those included the fact that the sub-postmasters made personal investment when they were buying a leasing or a premises for the Post Office. Their role was more like that of an employee than a kind of normal business partner. And trust was really integral because they were handling money on behalf of the Post Office. So if you do have a relational contract, what obligations are implied? So it won't always be that onerous. The general definition is here. So you have to refrain from doing things that are commercially unacceptable. There's no obligation of loyalty, but you don't have to put the other party first. And it doesn't cut across any express terms of the contract, which is important to bear in mind. But what it does mean is you've got to act honestly, deal openly and fairly, and be faithful to the common purpose of the contract. So basically, you've got to be nice, but not too nice. So in the post office case, there was a really long list of obligations that were implied. Too many to mention here, but they were things like, the post office had to exercise its powers in accordance with good faith, fair dealing. It should have investigated the shortfalls properly, fully and fairly. It shouldn't have tried to conceal problems, and it shouldn't have sought recovery against people unless it had established that the shortfall was a genuine loss and not due to this software. So after this judgment and some other judgments on preliminary issues, the post office settled the case. Everyone got released from prison and had their convictions quashed, and got paid a settlement amount, which I don't think was actually that much in the grand scheme of things. And people had gone bankrupt and died waiting for the outcome of this case. So that's obviously an extreme example, but good faith can be asserted in normal commercial contracts too, and people are trying this more and more, as I said. So there's been a couple of recent cases involving joint venture agreements where good faith has been asserted, and Russell and Cartwright from last year is one of them. So here we had 4 partners in a property development joint venture, and one partner decided to leave. Just after he left, the remaining 3 partners closed a big deal, and the guy who had left said that they'd breached a duty of good faith by not telling him about this deal when he was negotiating his settlement. He obviously said, I would have asked for more money if I'd known they were about to close this big deal and get loads more cash. So rather than look, so the question here was, did they actually owe him a duty of good faith? And rather than look at whether this was a relational contract, the judge applied the usual implied terms test from M&S, which we looked at earlier. And one of the key issues here was that the JV agreement contains some specific good faith obligations. These were limited, but they were included for some particular clauses. So that meant that implying a general good faith obligation across the whole JV agreement would be inconsistent with the express terms. So no implied duty of good faith here. And moving on to what happens if you do have a good faith obligation and what it means in practice, we're back to Liverpool and another sponsorship dispute, which I think the judges are getting pretty sick of, seeing as they see loads and loads of them. So in this case, it was nearing the end of New Balance's sponsorship deal with Liverpool, and New Balance wanted to retain its sponsorship rights going forward. Under its agreement, it had the right to match any third-party offer that was received by Liverpool. Nike made an offer which had really generous distribution terms. New Balance went away and came back and said, yes, we can match this. And here the parties agreed that there was an implied obligation of good faith when New Balance was, saying that it could match the offer. So the question here, had New Balance acted good faith in saying that it could match the deal from Nike? And the question here was, would reasonably or honest people regard New Balance's conduct as commercially unacceptable? So this is the general duty of good faith we were just looking at. And here the judge said the answer was no. On the facts, New Balance had carried out an internal due diligence exercise. It had gone away, it had done this whole project trying to work out if it could match the terms. And it honestly believed, on the basis of that exercise, that it could meet these obligations. There had been some mistakes, but that wasn't enough to establish bad faith. And even though some of the estimates that the regional salespeople had made were pretty punchy, that they weren't reckless. So that wasn't enough to amount to good faith. So there was no breach here, and New Balance was found to have matched the marketing aspects of the distribution aspects of the offer. However, after a long judgment dealing with this, there's kind of 2 paragraphs where the judge finds that that New Balance had failed to match the marketing aspects of the offer because it didn't offer the same big name endorsements that Nike had. So moving on to the practical points here, I mean, as I say, this is something we're seeing more and more often. For example, we recently had a dispute between a writer and a production company where the writer was saying that the agreement was relational and subject to good faith. You can see how, for example, in something like a management agreement, depending on the relationship between the parties, in theory, that's something that could be a relational contract. So don't assume that it won't apply. It might do, and I think the law is going to continue developing in this area. If you don't want it to apply, think about excluding it. So you can either do this by excluding it entirely, or if you do include it in some specific limited circumstances, that makes it much less likely to be implied across the board. And if you do have a good faith obligation, think about what it means in practice. It's probably not going to be as onerous as in that post office case, on the, bearing in mind the kind of contracts that we're dealing with, but it does impose something extra. You have to act honestly, openly and fairly. So have a think about what that might actually mean, depending on the provision that it applies to. And that's it on good faith. If anyone's got any questions.
Yeah, so just one question. So in the New Balance case, you said that the parties agreed that there was an obligation of good faith. What was the basis of that? Was that just in relation to that particular obligation, or was that the contract?
Yeah, so that was they agreed that in relation to that particular obligation, that there was an implied duty of good faith, because otherwise, New Balance could just say that it could match anything without having to do so honestly and fairly. So the parties agreed before the trial that obligation to put forward a matching offer needed to be done in good faith, but it wasn't across the whole contract, it was that provision.
Okay, so you may have a situation where there isn't a general obligation of good faith in the contract, but in relation to one particular clause obligation there might be.
Yeah.
Okay. And then just then a comment is, just as Fran has said, we're seeing these arguments raised more and more, particularly where there doesn't seem to be any other basis for a claim. So you can see people are looking at contracts and say, well, I've got no specific contract breach that I can point to. Let's throw in a good faith argument here because that might give me something to play with. And a lot of the time, these look like very spurious claims. But nonetheless, because of the development in this area of the law, it's something that we're increasingly having to deal with. And on the flip side, if you're in the position where you think, well, maybe this was a relational contract, do have a think about whether or not there is a good faith argument that you could put forward there, because this is a changing area. It's developing, and as Franja says, the courts are saying this is as yet unsettled. So I'm just seeing, sorry, whether we have another question here. So the question here is, I most often see good faith as a promise to act in good faith when negotiating further terms, long form agreements. Yeah, exactly. We do see that quite a lot. And the question there, Franja, is, would you advise against relying on good faith terms in that way?
Yeah, I mean, I think, agreeing to negotiate in good faith is the one that you most commonly see. I mean, the difficulty there is that, that can sometimes end up in agreement to agree territory, because how can you prove whether or not someone's negotiated in good faith or not when you're agreeing a new contract? I mean, I think one of the questions there is, if you have that obligation to negotiate in good faith for one specific clause, that means that you're much less likely to have a good faith obligation implied in the contract generally. So sometimes that can be a way to address this issue.
Okay. All right. Thank you, Franja. So we're going to move on now to, if anyone's got any more questions, then we can answer them at the end. We're going to move on to, you have a binding contract, you know what it means, you know what your implied obligations are, if there are any, and then things go wrong. So I'm going to deal with three issues here. One is about penalty clauses, one is about exclusions of liability, and then a quick look at force majeure. As I say, if anyone's, I've just seen we've got another question through, we'll pick that up at the end. So penalty clauses, our myth here So this is a common one. If it's not a genuine pre-estimate of loss, it's an unenforceable penalty. So we often see contracts which contain liquidated damages clauses or clauses setting out penalties if there's a breach. So, for example, a huge increase in interest rates if you fail to repay by a certain date. If those clauses, if it is a penalty, then it won't be enforceable. And the general principle here under English law is that you shouldn't punish a breach, but the law is there to protect the legitimate interests of the innocent party. So we see this rolled out over and over again. If it's not a genuine pre-estimate of loss, it's an unenforceable penalty. And the question is whether or not that is true. And for this, I'm going to take you back 100 years in a moment. But first of all, I'm going to take you back to 2015, which is the Supreme Court case in two cases, actually, but commonly known as Parking Eye. So that there was Cavendish and Makdessi, and there was Parking Eye and Bevis. So these two cases were dealt together. And in that case, the Supreme Court went through the long history of the penalty law in detail, from its equitable roots back in the 16th century to the present day. And its conclusion of 100 or 400 years of case law was the penalty law in England is ancient, haphazardly constructive edifice which has not weathered well. And the Supreme Court sought to put that right. So, taking you back to a bit of history. So the pre-estimate of loss, the genuine pre-estimate of loss point, is one of four tests which were formulated by Lord Dunedin in a 1915 case known as Dunlop, and it's been applied ever since. And since then, we've had this traditional approach of a separation between a penalty or a deterrent, which is unenforceable, and a genuine pre-estimate of loss, which is enforceable. And what the Court of Appeal said in Parking Eye was that rigid distinction is not helpful. So the Supreme Court judgment includes different formulations, but in essence, it will be an unenforceable penalty if I'm going to call it a penalty, is a secondary obligation, and it includes a detriment which is out of all proportion to the legitimate interests of the innocent party in the enforcement of that primary obligation. And as a general principle, there is a presumption against penalties. So the first point is it a primary or a secondary obligation? If it's a primary obligation, so that's a standalone obligation. It's a promise to do something, to pay, to carry out a particular act. And a secondary obligation only arises if it's triggered by something else. So the failure to pay or the failure to carry out a particular act results in a secondary obligation. So if X, then Y. If you don't pay, you must pay interest at 20%, for example. So you're only into penalty territory if it's a secondary obligation. I'll come back to that in a second. So in a commercial context, the strong presumption is that parties themselves are the best judges of what's legitimate in dealing with the consequences of a breach. And the courts are generally reluctant to say that something is a penalty, where it's been freely negotiated between commercial parties, no duress, no misrepresentation. That's the general principle that the court's approach to contractual interpretation is commercial parties should be free to do what they want. So we've had a lot of cases on penalty clauses since Parking Eye, and we've picked out two on interest rates, one from 2019 and one from this year, 2021, to see how they've applied Parking Eye. So the first is Cargill. This is about steel. So Cargill made advance payments, and UTAM, the defendant here, was then supposed to either deliver the steel or repay the cash. So Cargill paid $60 million, but UTAM didn't deliver anything and they didn't repay it. So there was a dispute over the interest rate and whether that rate was an unenforceable penalty. So if they failed to repay on time, there was default compensation of 1 month LIBOR plus 12%. So that's the first case. And the second is Ajuga Investments from 2021. Again, a case about interest rates. So there was a bridging loan agreement as part of a larger property transaction. And Victory Game, the defendant, lent £800,000 for a period of 4 months. And then it wasn't repaid. There was default interest at 12% per month, compounded monthly, which resulted in a 400% increase in the interest rate prior to default. So the question in both of those cases, were these interest rates unenforceable penalties? And the judges in both cases applied the reasoning from Lord Mance in Parking Eye in the Supreme Court judgment. And to simplify, the test that Mance proposed was to look at, firstly, what is the business interest that is being protected and served by this clause? And is that provision extravagant, exorbitant, or unconscionable? If it's not, it's enforceable. So the same test applied in both cases, but with different outcomes on the fact. So in Cargill, the court said that Cargill had a legitimate interest in ensuring that the money was being repaid, as you'd expect. And it also said there was good commercial justification for the rate. The borrower was a credit risk. The rate was justified, particularly given the market. It wasn't unusual for that market. As a result of which, the increase in interest rate was justifiable. Whether or not it's a genuine pre-estimate of loss, it was protecting the legitimate interest of the party seeking to impose it. And then in the second case, Ajuga, a different result. So again, Victory Game had a legitimate interest in being repaid. But importantly here, the penalty rate that they were seeking to impose, the judge said was extravagant and exorbitant and oppressive. And it wasn't in line with market interest rates. And therefore, it was an unenforceable penalty. Again, the lender, in one factor here was that the lender here had security for the loan and also had the benefit of personal guarantees. So those kind of factors will play in to how much you can increase your interest rates if you're looking to be repaid. So interestingly, in Ajuga, the judge also said, so he didn't like a 400% increase in the interest rate, but he says, as a rule of thumb, I would probably have accepted 200% in the event of default. And then the evidential burden would have had to pass to the lender to justify a greater increase. But that's his own formula. Remains to be seen whether that's going to be approved by a higher court. I suspect it may not be. It's very hard to apply a rule of thumb in any of these cases, given all of the background facts that you have to look at. So some practical points from this one is that bear in mind that you can, or your contracting party, your opposing party, can protect your legitimate interest in a commercial contract, as long as there's no evidence of oppression. And as we know, that's quite hard to show. Sometimes you will look at a clause and you think, well, that's so outrageous, there's no way that's going to be enforced. So we won't even bring it up as a negotiating point, we'll just agree it. That can be quite dangerous because it's not just about genuine pre-estimate of loss. You've got to think about, well, what's the interest that they're trying to protect here? And is what they're doing, is what we're trying to impose here legitimate in protecting that interest? Also think about, can you draft these things such that you're not in penalty territory at all? So bear in mind that you only have to think about unenforceable penalties if you're looking at a secondary obligation. So there may be situations where you could draft something as a primary obligation. So a case quite a while ago now with Henning Berg, who was then the manager of Blackburn Rovers Football Club. So there was a clause in his contract which said that the club was entitled to terminate early if they paid him £2.25 million as a payoff. So the club decided to terminate early. And then the question was, were they obliged to pay 2.25 million? And the club said, well, that's an unenforceable penalty. It's not a pre-estimate of his loss. But the judge said, no, this isn't a penalty provision. This was a contractual right that you had. They were exercising a contractual right, and that had a specified consequence, which is that they had to pay 2.25 million. So there may be ways of drafting these provisions where you're in primary obligation territory and don't have to worry about penalties. The other way we've seen it, particularly with repayment provisions, is actually you turn it round, and rather than saying it's a penalty for paying late, you get a bonus if you pay early. So you say the interest rate will be 15% if you repay on the 31st of March or later, but if you repay before the 31st of March, it's going to be 10%. So you switch it round, so as a bonus rather than a penalty. So some drafting points that you can think about there, and also as a general principle, don't be thinking about genuine pre-estimate of loss when you're looking at a penalty, what you think might be an unenforceable penalty provision. So I'll pause there before we go to exclusions of liability. So
there's a question here. Does express wording after the penalty stating that the parties acknowledge and agree that it's not in fact a penalty affect the court's interpretation of the clause? And will the court give this weighting regardless of whether or not the penalty does actually protect legitimate interests?
I think that if you're looking to rely on that, what you might want to say is that the parties accept that this is protecting a legitimate interest of the other party, and acknowledge that this is a reasonable provision. I think wording there that parties understand, kind of demonstrating that they understand that they've considered penalty provision, may go some way on the interpretation question. I don't think it would be the sole answer, because the court is still going to look at what are the circumstances here. But I think given that, as I said, the general principle is you leave commercial parties alone to do what they want. And if the commercial parties have put a clause in there that says, we've thought about this and we agree that this is okay, I think that is going to go some way to saying that should be enforceable. Okay, so that's it on penalties. Thank you. Moving on to exclusions of liability. Exclusions and limitations. The case I'm going to look at is exclusions. But first, I mean, these clauses are some of the most important clauses that you'll ever have in a contract. So we deal with it in two strands, as you'll know. You'll have exclusions of particular types of loss, and then a limitation of liability. So for those types of loss that you can claim, the maximum you can claim is £500,000, let's say. And these, as I say, as a litigator, these are really fundamental because you may have a flagrant breach of contract, and it may be that the other side has suffered loss of £1 million, let's say. But if you have an enforceable exclusion and an enforceable limitation of liability, it may be that your exposure is only £100,000. So these are really fundamental. You can really screw up badly in performing your contract, but if you've got a good limitation and exclusion clause, that's going to give you a great deal of protection. And we look at these, we always look at these in a dispute context, and it's often the first clause which I'm looking at. First, I'll look at governing law, and then I'll look at exclusion and limitation of liability. So this case I'm going to look at is about exclusions. And the question that we often have here is it a direct or indirect loss? And if it's an indirect, and can we claim for loss of profits? Those are two of the questions which we see a lot of the time. There's nothing new here, but I make no excuse of dealing with it again, because these questions come up over and over again. And fundamentally, it's a question of contractual interpretation. So here's my myth. Loss of profits is an indirect loss. Hopefully, nobody thinks that's true, or at least not as a general principle. It's not always true. It can be, and sometimes it's not. So our case here, 2Entertain Video and Sony DADC. So this was a case about the warehouse fire, which was the warehouse that was burnt down, I think it was in Enfield, in 2011 in the London riots. 2E was a subsidiary of BBC Studios, used solely for warehouse storage and for the distribution of DVDs and CDs. And £40 million worth of their stock was destroyed. And also the distribution services were disrupted. So the insurers made a payment, but 2E also sought damages from Sony, which was limited to a £5 million contractual cap. So the exclusion clause had two relevant parts. So 10.1 was about liability for loss of goods. And that was limited to the manufacturing replacement cost of the goods. But here, the fire had also affected Sony's ability to provide the distribution services. So the question, therefore, was what did 10.3 mean? So here's our exclusion of indirect and consequential loss, or so we think. So neither party shall be liable in connection with the supply or failure to supply the logistics services for any indirect or consequential loss or damage, including, to the extent only that such are indirect or consequential losses, but not limited to loss of profits, loss of sales, loss of revenue, etc. So the question was, what did that mean? And the other question was, were we in loss of profits territory? Was that a direct or indirect loss? So two questions, were the loss of profits direct or indirect? And secondly, were they excluded by this provision? So if you take out the brackets here, you have a clause that says there is an exclusion for any indirect or consequential loss of damage, including but not limited to loss of profits, etc. That's problematic, because you then wonder whether loss of profits is meant to be direct loss of profits or indirect loss of profits. So what may have happened is the draftsperson thinks, okay, let's make this clear. We only want loss of profits to be excluded if it's indirect loss. So we put the words in brackets. So indirect or consequential loss of damage, including, to the extent only that they're indirect or consequential, loss of profits, loss of sales, etc. Maybe that's what happened. I don't know, pure speculation. So on construction, the question is, what does that mean? So you applied normal rules of interpretation to exclusion clauses. You look at the words that are used in the context of the wider agreement and the commercial context. And the court said here, this was unhappily drafted. It wasn't clear what the impact of the words in brackets was. Were loss of profits excluded entirely, or only if they were indirect? And bear in mind here, there's no defined meaning of what indirect loss means. Unless you have a definition in the contract, you're going back to first principles, Hadley and Baxendale. The first limb of Hadley and Baxendale, direct losses are losses which arise as a natural consequence of the breach. Other things are indirect losses, second limb. So what the court said here was the direct and natural result of the fire was the destruction of the goods and the warehouse. And this caused loss of profits and business interruption losses. Those were direct losses, and direct losses were not excluded on the interpretation of this contract clause, as a result of which Sony had to pay £5 million. So, as I say, none of this is new, but we often still see confusing drafting on exclusion clauses. We still quite often see indirect or consequential loss, including loss of profits. That leaves open a question as to whether the loss of profits that are excluded are direct or indirect. So if you want to exclude a loss of profit claim, and bear in mind that a lot of loss of profit claims may be direct loss, then make it clear. So indirect or consequential loss and loss of profits are excluded. Or better drafting, you have a list of all the particular types of loss that you want to be excluded. And it is often, this direct indirect point is often misconstrued. So people often think that loss of profits is always going to be an indirect loss. and that just isn't the case. There's also, I'll just throw this in, another principle under a case called the Achilleus, where almost regardless, well, not regardless, but in addition to particular interpretation arguments of your exclusion of limited liability clause, you can look at to see whether or not the parties had assumed an assumption of full liability for a particular type of loss. That's, again, a question of contractual interpretation. So be careful with your drafting. If you're looking at something that's gone wrong, beware of advising your business that, oh, this is a loss of profit claim, and therefore it's excluded because it's an indirect loss, because often that won't be the case. So that's exclusions of liability. Just going to pause there for a second before we move on to force majeure, excuse me. Okay, so no questions on that at the moment. We're now at 10:35, so we're in good time, and we're on number 9 of 9. We've come to the end almost. This is our old friend, force majeure. And as I said, we couldn't possibly do a talk in 2021 without looking at force majeure clauses. And also going to look at material adverse change provisions, which is something very similar to force majeure, which you'll see in sale and purchase agreements. So force majeure has featured in a number of disputes that we've dealt with over the last 18 months. We had a training session on it right at the beginning of lockdown back in April, however many years ago it was. But actually, surprisingly, maybe we haven't seen as many as we thought we were going to have. And we certainly haven't seen that many decisions on them, but I suspect that's because the very substantial force majeure cases will still be running through the courts. But we have had some. And we have had people looking to get out of contracts based on force majeure, as you would expect. So I'm going to look at 2 issues here. The first is whether there are any particular rules of interpretation of a force majeure clause. We often see people saying you've got to construe them strictly. And then I look at a case, an injunction case actually, on the effect of force majeure in a COVID scenario. So 2 myths here. The first is force majeure clauses should be construed contra proferentum, so against the party that's relying on them or against the party that introduced the clause into the contract. So essentially, do they have to be strictly interpreted? Is there a special rule of interpretation? And then the second myth is we can get out of this contract because of COVID. So the first on interpretation, are there any special rules? So looking first at Target Rich and Forex, I've got 2 cases for you here. The first is about foreign exchange trading. These are long, factually complex cases, so I'm not going to go into the detail. I'm just going to touch on them for a bit of context. So the first one is about foreign exchange trading. This was about the Swiss flash crash in 2015, which is essentially where the Swiss government removed the peg between the Swiss franc and the euro, and that caused market mayhem for about 2 hours on the Swiss financial markets. As a result of which FCM, which was a trading platform, suspended activity. And this caused Target Rich, its customer, to suffer a loss because a number of its foreign exchange trades were not executed. And Target Rich brought a claim against Forex, and Forex relied on a provision in this contract, a force majeure clause, which excused them from liability for breach if there had been an exceptional market event. An exceptional market event was defined as this. So the suspension clause of regulation, imposition of unusual terms, and then excessive movement, volatility, or loss of liquidity in any relevant market or underlying instrument. So the question was, how should that be interpreted? should you just apply the normal principles of interpretation, which Franny has been through? You look at the words, you see what they mean, you look at the background context. Or should it be interpreted strictly, like an exclusion clause, perhaps? And what TRI was saying is that we have to construe this strictly. And it was so wide, this effectively an exclusion, this force majeure clause gave Forex such a get out that it offended the main object rule as a matter of contract law. So this is a principle that says that on exclusion clauses that you should construe them in such a way so as not to deprive the innocent party of the main benefit of the contract. So here we had a contract which to allow speculation in volatile foreign exchange markets. And what Target Rich said was, well, this contract is meaningless if there's a volatile market and Forex have no liability if they don't perform their obligations as a result. The whole thing is pointless. But the judge did not agree. So they said there is no special rule of interpretation when you're looking at force majeure clauses. You look at the words, you look at the context, and you decide what it means. And he said, well, the clause was engaged whatever approach you took to construction. The wording was clear, and Forex was not liable because essentially they could rely on the particular wording of the force majeure clause that they had. And the important thing there, which is relevant on the force majeure clauses generally, is just because you have a force majeure clause doesn't mean you're going to be able to rely on it. You have to look at the particular words, as you do with any other contract provision, to see what is its effect. So our second case, again on a question of interpretation. So this is a case about a material adverse change clause. So these are common in corporate transactions, and they allow a purchaser to pull out prior to completion after exchange if there is a material change in market conditions in that interim period. So it's very like a force majeure clause. So there's a very long judgment looking at lots of different things, but there's some useful guidance on interpretation. So this was a case between Travelport, who produce booking software and other software in the travel industry, and WEX, which was essentially buying shares in two Travelport companies. And there was a material adverse change provision in there as a condition precedent to closing the deal. And WEX wanted to withdraw from the acquisition as a result of COVID. And the material adverse effect clause included pandemics, but it said that would only apply if the sellers had been disproportionately affected compared to others in the industry. And the big question on interpretation here was, what did industry mean? Did it mean the travel sector? Did it mean the providers of software technology? What did it mean? But the key question for us here is whether there was any particular rule that should apply to the question of interpretation. And again, the judge said, well, we applied general rules of interpretation. There's no specific rules for interpreting material adverse effect clauses. And on the industry's point, that was the key issue in terms of the meaning. And the court here said, even though it's part of a boilerplate clause, this is a major and heavily negotiated contract, which has been carefully scrutinized by lawyers. And we have to assume that the wording here has been used wittingly and advisedly. So again, coming back to this principle that if you've got commercial parties negotiating with each other, the courts are generally going to leave them alone and honour the terms of the contract that they have agreed. So then a quick note about the effect of a force majeure clause. And one case for you here, a COVID force majeure case. This was actually an injunction application, so not a final determination, but quite interesting nonetheless. So this was Fibula Air and Just US Air. So Fibula chartered an aircraft from Just US just before the pandemic. And they were going to use that aircraft for charter flights between Turkey and Romania. And the first payment was due on the 18th of March 2020. Cast your mind back to those days, beginning of lockdown in this country, a little bit later, I think. But here, Fibula said that the lease terminated on the 17th of March under the force majeure provisions, and they demanded a return of the deposit. So the force majeure clause said this. It said, in the event of a force majeure situation, they won't be responsible for any failure or delay in performing their obligations in the event of a force majeure situation continuing for a period of 10 days or longer. Either party will be free immediately to terminate the leasing of the aircraft under this agreement by notice in writing. So at that time, flights had not yet been suspended between Turkey and Romania. Turkey announced a suspension on the 28th of March, but there was no suspension by Romania until April. So the court said essentially no force majeure event had arisen at that time. It may have been that it was about to. Everybody was thinking some countries had already imposed travel restrictions, but there wasn't any such travel restriction relevant between Turkey and Romania. As a result of which they weren't entitled to rely on the force majeure provision, and the contract should have continued, and they should have paid the instalment payments. So essentially it was a case of relying too early. And as a general point here, just in terms of COVID force majeure clauses, is if you're still putting in a force majeure clause because you think that's going to give you a get out if something COVID related happens, that's not a very good idea anymore. And that's why we see specific COVID related clauses which either make it clear that a COVID related event is going to be part of a force majeure event, or you have separate COVID clauses which spell out exactly what will happen if there is a COVID delay or cancellation on a production, for example, quite specific obligations, because the whole point of force majeure is that this is generally something which is unexpected, and nobody can be saying at this point that something related to COVID is going to be unexpected. So some brief practical points on that is just look at force majeure clauses like any other. From a drafting point of view, force majeure is one of those boilerplate things, or maybe not now, but it certainly was for a long time, that people would stick in, not really pay very much attention to it. But you do need to pay close attention to it. You need to look at what it says. You need to see whether it's going to apply to the particular situation that you have in mind. And if somebody's coming to you and say, look, we've got a force majeure clause here, this is what's happened, can we get out of the contract? Again, just a question of interpretation. How does it apply to your particular situation? No specific rules to say you've got to look at them narrowly, just apply those general principles. And be very careful if you're drafting contracts to ensure that COVID issues are going to be excluded. That's quite a difficult thing to do from a commercial context. And that is force majeure. So we have now come to the end of our 9 myths in 90 minutes. It is now 12 minutes to 11 on my clock. If anybody has any further questions now, we'll be very happy to answer them for you. If anybody has any burning questions that you would like to fire at us, do contact me or Frania. Our emails are here on the slide. But if we don't, I will leave it there just to say thank you very much for attending. It's been a pleasure to not see you, but very nice to have you here. I hope that's been helpful for you. And we look forward to seeing you in person at some point. Thank you very much for being with us.
Thank you.